Actually, thank you, everyone. Please be seated. We are typically a 7-member court, and tonight Justice Wiggins is not with us tonight, which from the size of the table, that might be a good thing. So anyway, we would like to thank everyone for coming tonight, spending a part of your evening with us to see a little bit of what we do. This is called Court on the Road. Tonight, the case that's going to be submitted to our court is the State of Iowa versus Charles Ross out of Cerro Gordo County. State is represented by Katie Krickbaum and Mr. Ross by Dylan Thomas, correct?
Yes, sir.
You may proceed, Mr. Thomas.
Thank you, Your Honors. May it please the court, counsel. First, I'd like to briefly explain why we have to go beyond the literal given definition of theft detection device in this case.
You know what? Can you either get a little closer there or speak up a bit?
Sure.
Thank you.
Thank you.
Glad you said
First, I'd like to briefly explain what our position is on why the court needs to go beyond the given definition of theft detection device in this case. The first reason is we would submit that the term and its given definition are in conflict to some degree because the definition, the clause that says or any device, really allows for anything that's attached to a good for sale to be considered a theft detection device. It doesn't have a reference to theft detection, which would seem to be a natural part of the definition of theft detection device.
Well, why isn't this a theft detection device in a sense? I mean, it's a cable and a padlock, but if you go to the farm or country store and see somebody loading up a tractor in the back of the pickup, you might not think anything, but if you see them struggling with a cable and a padlock and so forth with a instrument, that's different. I mean, it is a theft detection device in a way because it makes it more difficult for someone to spirit away the equipment.
Our response to that, and part of it was in the brief that we'd submit that a padlock and steel cable are the purpose is a theft prevention device rather than a theft detection device. Part of our argument tonight is that when the court decides on the definition of theft detection device, the aspect of the device that alerts somebody to a potential theft needs to be more than just an incidental alerting. So like in this case, the state has argued that the fact that there was a cut padlock or a loose cable left at the scene after the lawnmower was taken alerts a person or the store, the merchant, that something was stolen. But we would submit that, and it relates to part of the reason that the court needs to go beyond the given definition, that if you allow for anything that's attached to a good for sale to be a theft detection device, you run into a due process void for vagueness problem.
Well, what are your specific concerns? I mean, give me examples of the kinds of things that would be attached to a good that you think would raise constitutional problems.
Well, in this case, there was not only the padlock and the cable, but it appears from the photographs that this lawnmower was actually attached to 4 or 5 other lawnmowers also on the sidewalk. So by this definition, a person would be or could be alerted that where last night there were 5 lawnmowers, today there's an empty space and there's 4, that those other 4 lawnmowers attached to the lawnmower that was stolen are also a theft detection device.
But the item at issue is still a padlock. So what are the kinds of things you're concerned about, this parade of horribles? What kinds of things are affixed to goods that make this constitutionally unworkable?
Well, it's anything that's attached to the good. So if those other lawnmowers were attached through the cable, the same as the padlock was, they would also be attached. And any difference in them that's incidental to the theft could give some sort of alert to a person. So there's also the cement block in front of the
I
lawnmower.
understand that, but you're saying this definition is very broad, and it would raise a whole host of concerns about things attached to goods. And I want to know a couple examples, other than this padlock case, of the kinds of things that would be affixed to goods that you think would create constitutional concern.
Sure. So as mentioned in my brief, the peg that a good is hanging from, if there's an empty space, that could alert somebody that there's been a theft. They use a pair of scissors to cut it from the peg. Items of packaging.
Do you think those would qualify as devices within the meaning of the statute?
They
A
could.
rack?
Sorry, Your Honor. I think they could if this definition is read so broadly, because a device, it just basically has to be something that serves a purpose. A package.
One
could be a
example that
device.
kind of suggests itself to me is, when you get pop and it's a six-pack and they're held together with one of those plastic things that you're supposed to cut apart before you throw it away so it doesn't go in the landfill and hurt birds. If you remove the pop from the plastic, because say you want to buy one bottle of pop instead of all six, have you now violated the statute?
If you read it by the given definition, I think it could. It would be a device. That plastic ring is an item which has some purpose in its design. It's attached to the soda cans, and if the state's argument that it just provide any indicia of a possibility of a theft were to be adopted, the fact that there's an empty space there where one of the sodas was would serve that purpose and meet the definition.
Counsel, I think you're conceding too much. Doesn't any device, when you read the statute as a whole, have to be a device that's intended to alert the merchant of a theft by an alarm or something like that, not just something that happens to be attached?
Yes, and that's our position, is that when you read the statute as a whole, specifically the definition immediately preceding the definition of theft detection device, under theft detection shielding device, which the last clause is any other system designed to alert a person of a possible theft. And what we're submitting is that should be read into the definition of theft detection device in order to limit that. So it would have to be, in the case of a six-pack plastic ring, it's not an item that is designed to alert somebody to a possible theft. The purpose is different for transportation, packaging, those sorts of things.
I think of when we used to get music by buying a compact disc, and it'd have that plastic radio thing. So if you walked out the store without buying it, alarm would go off. And the store, the checkout, they'd pry that thing off with a tool. And if you came in with that tool yourself and removed it, clear violation of this statute.
Yes, thank you, Your Honor. And I think when you look at what seems reasonable to be the purpose of the statute, it seems like that situation where somebody comes in with the tool to remove the plastic anti-theft device from an item, you potentially had a donut hole in the law before this law was passed. Because if you catch somebody in the act doing that and they haven't damaged the property, they haven't committed a crime. They haven't stolen the item yet. There's a potential for a criminal mischief charge if there's some damage, but if there's not, then how do you prosecute that when it's a serious concern that what they're attempting to do is conceal their planned theft? And so when you're looking at that as the purpose for this statute, it seems a natural extension of that to include in this definition only devices which are designed primarily to or have a significant purpose in their design to alert a person to a potential theft.
I have a question for you, sir. I believe it was in the state's brief, they brought up a Kansas case, and within that Kansas case, there was a Mississippi statute, and there's some other states that have a similar statute that defines a theft detection device to mean any tag or other device that's used to prevent or detect theft. Would we be here today if Iowa's statute was similar to that statute?
We might not. In this case, in the trial court level, it seems like there was some confusion over the definition of this crime. So I don't know if that would have kind of slipped through the cracks like this did. But certainly I would agree that if that clause was added to this statute, that the padlock and steel cable would not qualify because their design is not in the same way that the theft detection devices that you see inside a store to set off an alarm or otherwise alert the merchants to the potential theft.
That's the point I'm trying to make, the distinction between prevention and detection. Could you elaborate on that? Do you think Iowa's statute is your argument that the device referred to, the padlock and chain, I just want to hear what your argument is regarding prevention when the code says detection.
The theft prevention would not apply, or in other words, a device that was designed for theft prevention I don't think applies and meets the definition of this statute. I think the purpose of the statute was remedying that wrong, or remedying that problem of these ubiquitous electronic or magnetic or however they're produced theft detection devices that set off an alarm when somebody leaves the store without purchasing them.
Well, you concede it's a device, I take it. The cable and the padlock is a device.
Yes, Your Honor.
Okay.
That is,
Yeah.
but
And the legislature, for whatever reason, says any electronic or other device attached to the goods. I mean, aren't you rewriting the statute? You're carroting in. You're being code editor a little bit. You're adding in language. The legislature creates its own definitions. If they say a pineapple is a 3-inch screw, a pineapple is a 3-inch screw. And haven't they said a theft detection device is a broad category? Any device? Other device?
I would respond to that, Your Honor, by I guess, going back to the first comments that I think when interpreting a statute, the court has to look at the legislative intent, and the court can't or shouldn't interpret a statute such that the legislature's motives were to produce some sort of Orwellian language change where a theft detection device really means any device, and the theft detection part you might as well leave out because it has no meaning. The other aspect of that in this case is if it's so broad that the average person isn't going to be able to know what the law means from reading it, then you have a due process problem under the Iowa.
Well, but if I read the statute, and I was going to take bolt cutters to a cable and a padlock, I think I might have some exposure. Any device attached to the goods. If I read that statute and I'm out there at midnight with my bolt cutters, I think I might have notice, don't you think?
And I guess our response to that would be that it's the definition of a theft detection device, and I think the average person reading that would assume that there's some relation to theft detection, even if the definition or perhaps there'd be confusion about what it means because the term is theft detection device, and then the given definition renders the theft detection part meaningless in it.
But isn't that concern somewhat limited by the fact that the defendant also has to possess a tool to overcome or detach the theft detection device, right? I mean, I still don't see what fact pattern it is that raises a lot of concern for you. I mean, this defendant had a bolt cutter, a moving van, gloves, the whole thing. It seems like he should have assumed that there was criminal liability attached to that. That doesn't seem odd to me at all.
Yes, and there was criminal liability. He was convicted of a D-felony theft, and I think that's what he would have, and a person in a similar situation would have apprehension about as far as running afoul of the law and what criminal statute might attach to it. The theft detection device definition, the problem comes in where if you're looking at a theft detection device, something that's going to set off an alarm or alert store personnel that something's being stolen or potentially stolen, if you don't have anything related to theft detection in that definition, you could just have the plastic overwrap or anything attached that if they use a tool and you know, section 2 of this statute that doesn't have to do with the tool, just making it illegal to remove a theft detection device would have the same definitional problems that if you take the plastic wrap off, you could be subject to this, even though the average person wouldn't say that plastic is a theft detection device in the packaging.
Thank you. You may sum up.
Thank you.
Thank you. Ms. Krickbaum? You might need to adjust that microphone.
Just a little bit. May it please the court, counsel. My name is Katie Krickbaum, and I represent the state of Iowa in this case. Mr. Ross agrees that the language of the statute at issue is not ambiguous, and he concedes that, taken literally, the definition of theft detection device includes the padlock and cable system used here.
Well, I don't agree with that. It seems to me device is kind of an ambiguous word, right?
I don't think device can mean more than one thing. Device, I mean, we can look to the common usage of the word, and it means something devised or contrived, such as a piece of equipment or a mechanism designed to serve a special purpose or perform a special function.
Yeah, but you got to consider the context of where the word is. I mean, the word's meaning is in part controlled by the forest around it. You really think the legislature wanted to criminalize detaching the soda pop, which was the example that was offered, you know? That's a device, and that doesn't seem right.
Well, I have two things. The first is that I do think that the legislature intended for this to be broad. I think that the definition that it used is intentionally broad. But I also think that device, although it is a broad term, it means something. So equipment means something, mechanism means something. We don't, so whether a piece of plastic wrap or some plastic attached to soda bottles, whether that's a device is something.
Right, but if you look at Scalia and Garner on their treatise on statutory interpretation, which is now kind of coming into vogue as sort of the go-to book on statutory interpretation, they say when you have a defined term in a statute, one of the things you shouldn't ignore is what you're defining. And here what you're defining is a theft detection device. And if you just read the word device in the definition in a vacuum without paying attention to it, I think they have some fancy word, the definiendum, without paying attention, and don't pay attention to that and just focus on the definiens. I don't know which is which, but you get the point that you have to look at the term being defined, right?
I think you do, but I think the term, you also if the language is plain, you don't use the term itself or the heading or the label of the statute to inform your definition. So in this case, the legislature chose to act as its own lexicographer, and it chose to define this as any electronic or other device attached to goods, wares, or merchandise on display. And so that's what we need to, that's what the definition is.
But
Go ahead, sorry.
that definition is contained in subsection 4, which is immediately before that defines theft detection shielding device. And so having already defined that term with reference to a system designed to alert a person of a possible theft, and then it goes right into the definition of theft detection device. Doesn't that part of that same subsection inform what is meant by theft detection device?
I think it does. I actually think that if you look at that definition of theft shielding device, it actually says designed to shield merchandise, designed to alert a person. I think that the design to does not appear in the definition of theft detection device for a reason. But I'm going to move on from this because I don't.
Oh, I'm not ready to move on
okay.
yet. I have, on that same note, the title of the statute. I know that doesn't always mean anything, but it is very helpful. Theft detection devices, dash, shield or removal prohibited. So doesn't that infer that both of those categories are referring to theft detection devices?
Yeah, I mean, I think I agree with you that the thing is that the statute is theft detection device is defined here, and it is defined with using the words that the legislature chose, and I think I just think it's a very broad term statute. But I will say that we do not, even accepting that the statute requires some type of detection, the defendants, there is still a factual basis here. The padlock and the cable used here still qualifies as a theft detection device. Detect means to discover the true character of or discover, determine the existence, presence, or fact of. A cut padlock and loose cable would alert the owner of the mowers that they were stolen rather than having been moved to a different area of the store by another employee. The statute surely does not require that the object's sole purpose or function be detection of theft, nor do the detection properties of the object need to be immediate or even successful. So I think it makes sense in this case that this is the type of theft detection device that was used because it was outside the store. The lawnmowers were displayed on the front, in front of the store outside. There's no doors or metal detectors between the front sidewalk and the parking lot. This has a theft prevention element, but it also has a theft detection element, and so for that reason, it falls within the statute.
So if it was inside the store, that would be different?
No, I don't think so. I just think that it just makes sense in this instance that they used a more low-tech.
I think you were the one that cited the Armstrong case out of Kansas.
Yes.
And those statutes within it, including the Mississippi one. I'll ask you the same question. Do you think we'd be here tonight if Iowa's statute was written like Mississippi's?
We may still be here because they have a different definition of theft detection device remover.
But don't they talk about theft detection and prevention?
And prevention, yes, they do.
And that is a key word that is not in Iowa's statute.
It's not, but other state statutes say things like tool or device specifically designed or manufactured to be used to remove a theft detection device, device designed for use or primarily intended for use in removing a theft detection device. So they're more narrow as well.
I don't think the issue is as much whether or not it's a device. I'll give you that it's a device. What's it for? What was the purpose of defining device? Why was it even talked about? That's where I want to get to, prevention versus detection.
Well, I think that I guess the point I'm trying to make is that detection, the padlock and cable serve both purposes, and just because it serves prevention also doesn't mean that it is not a theft detection device.
Does the cable standing on its own meet your definition of the word device?
I think that would probably, I think yes, but I don't think that, I think we have a stronger case with the padlock and the cable both, but I think that the state's position is that the cable itself, if it was attached, secured in the same way.
Is it your argument that anything that makes the theft more difficult makes it more likely that the thief would be detected? Is that your point?
No, I don't think that's the point. I think that the point is that as long as it alerts the owner that something was unlawfully taken, that it has a prevention element to it.
In this case that did not alert, wasn't it an employee who saw something going on?
Yes, but had that employee stumbled upon the cut lock, 20 minutes later, he still would have been alerted to the fact that it was unlawfully taken.
Would a burglar alarm or a security camera be a theft detection device within the meaning of this statute?
Not if it's not attached to the object.
I guess I'm struggling with the thought that anything that alerts people that something is missing or stolen could have a purpose of theft detection. And I know it has to be attached, but if you see a broken window, I don't think most people, it might alert you that a house or store was broken into, but I don't think in common usage most people would refer to a window as a theft detection tool of any type. And that's kind of your argument here, is that the goods are missing and the lock was broken, therefore it's designed for detection purposes. That just doesn't follow for me.
I think I come back to it still needs to be a piece of equipment or a mechanism that is designed for a specific purpose that is attached to the object.
How about some Goo Gone? How about if I go into a store with some Goo Gone? I think that's what it's called.
I don't know what
Gooby Gone. It's gooey stuff that removes gooey stuff.
Okay.
But if I wanted to remove some stickers, because I think a good way to try and at least argue that I didn't take something is there's no price tag on it, it's mine.
I don't think a sticker is a mechanism or equipment. So I don't think that a sticker qualifies as a device.
Well,
So
what if your price tag was attached by the little plastic lining, and then you took a pocket knife and cut the plastic? Is that price tag is a device because it serves a purpose and it's attached to the merchandise? Does that qualify?
I think that's a harder question than the one we have here, and I don't think we need to define the contours of the statute to resolve this case. We're trying to determine whether the defendant pled guilty to. There's a factual basis for his guilty plea, and in this case, a padlock and a cable does meet that definition. So I think that's a good question. I think it's a harder question than the one.
Was the
before you.
padlock attached to this particular good? So if, from my looking at the pictures, there's a cable running across the front of the store, kind of snaking through these different lawnmowers, and then the padlock is attached to the end of the cable. And it seems like the statute says that the device is supposed to be affixed to the good itself and not something else.
It says attached to the goods, wares, or merchandise on display. So in this case, you're right. It's wrapped around and kind of snaked between each one of the lawnmowers, and so it's touching the lawnmowers, and it's kind of in some cases wrapped around different parts of it. The cable, and attached. It means connected or joined to something. I think that falls within the definition of attached.
Is there anything in the legislative history that might help us interpret the statute?
There wasn't. All it was just, all that I saw was just sort of a description of the words of the statute.
Well, if there's ambiguity or doubt and legislative history doesn't help us, why shouldn't we say, well, in ties, the defendant wins and the legislature ought to fix it? Before we criminalize something, we want to be on really firm ground, and this is quicksand.
I guess our position would be that the statute is clear and not ambiguous, and so the rule of lenity doesn't apply in this situation. But I do think that if you look at, the purpose of the legislature's purpose was to have a broad statute to criminalize a broad category of conduct here, and I don't think it's overbroad. And the defendant act. I think we just say it's not ambiguous.
Can you address the question of remedy? If we were to find that there was no factual basis here, and then, they probably couldn't make a factual basis, what would be the remedy? Would we start again and the plea agreement would be undone?
So typically, I think the court remands to give the state an opportunity to establish a factual basis. And then if it can't, the plea is withdrawn and the state can proceed accordingly. I think in this sort of situation where we all agree with what the facts are, our options are probably limited on remand on whether we could come up with a factual basis or not, because the facts are what they are. So, let's see here. I also want to point out there's one other reason why Mr. Ross cannot succeed on his appeal. Even if the court were to interpret the statute in such a way that the padlock and cable did not qualify, Mr. Ross's trial counsel cannot be deemed ineffective for abiding by the plain meaning of a clear statute. As Mr. Ross admits, the statute is clear, and the definition of theft detection device literally includes the mechanism used here. Trial counsel is not required to be a crystal gazer. One competent counsel has a duty to do is to read the charged statute and determine whether his or her client's conduct meets the elements of the crime, and that's what the counsel did here.
But haven't we said before that where there is no factual basis for a plea, that is per se ineffective assistance of counsel? We have a broad concept of ineffective assistance. Right. I've said that before.
Right.
Yeah.
I'm not arguing that it's not per se prejudice. I'm arguing that he didn't have a duty to make this argument below because he couldn't have, based on his reading of the plain language of the statute, he couldn't have assumed that the court would maybe go in this direction.
Couldn't assume it, but isn't it a claim worth making? That's what we've stalked out as kind of the test. I mean, it doesn't have to be absolutely clear that you'd win.
It could be, yes. I mean, it's not if he had looked in Iowa case law, there are no cases interpreting this statute. The other states, it's not like a percolating issue. Kansas has some litigation, but none of the other states do. I wouldn't say it's an issue that is, I think that our case law says that counsel needs to read the statute, and if there's something that reading the statute suggests to him that he needs to make that argument, then he does, but I don't think that is the case here.
I want to jump to something. In your brief, you say that Ross concedes on its face the definition of the term theft detection device does include a padlock and wire cable, and then you make reference to his brief. But wasn't that setting up an argument that would result would be overbroad and absurd? I'm just a little bit concerned about you saying that they have conceded. I don't see that as a concession.
I think he says that taken literally, the definition includes padlock and cable system, but that you need to read in some common sense and inject some meaning into the statute, and that's where I got that. And even when he started here, he did say the literal definition includes padlock and cable. If I may finish, I see my
Yes, you may. Briefly wrap up.
For all those reasons and those in the state's brief, Mr. Ross's trial counsel did not breach an essential duty here. We ask that this court affirm Mr. Ross's conviction and sentence. Thank you.
Mr. Thomas?
Thank you, Your Honors, again. May it please the court and counsel. I would like to briefly address the discussion of how broad the legislature intended the statute to be. Looking at the purpose, which we discussed some, and our submission is that the purpose is to remedy this hole in the law of potentially catching somebody in the act of removing a theft detection device.
If that's the purpose, then why doesn't a cable with a padlock that requires somebody to cut the padlock serve that same purpose? You had mentioned earlier that the whole is that if someone gets caught in the act but they haven't actually stolen the item, then there's not much that you can do. But wouldn't cutting a padlock in the process of trying to steal the lawnmower and getting caught in that act, doesn't that have that same hole?
We would submit that it doesn't, because the destruction of that padlock would potentially result in a criminal mischief charge. It might be something that would be undercharged, but I don't think it's the same type of problem that the legislature was considering. It was looking at this hole in the law in the context of a theft detection device.
So it's okay to destroy the electronic device or the little plastic thing that you put on clothes that spits out ink, but that's different than destroying a padlock?
For this statute, yes. And I think for the purpose of what the legislature was looking at, my best guess is that they were looking at, and I don't know if they were potentially being lobbied by merchants saying these are the theft detection and the systems that we have in place to set off an electronic or some sort of alarm at the exit to the store. But we have this problem where people are removing the theft detection devices to try to conceal the theft. And so we're looking for a remedy for that. Merchandise set outside the store with a padlock and cable seems to be a little bit different type of situation than what they were likely trying to address, and that might be why this is a...
Is it your position the statute is ambiguous?
Not ambiguous in the sense that it's susceptible to two meanings that a person reading it could say, well, it means either this or this, where a word might mean two different things, but potentially I'd say it's as written vague in how it defines a theft detection device, because you have the term...
Are you relying on the rule of lenity?
We would if the court agrees that the definition is vague enough that this would be a close call. We would submit that it's clear that the padlock and steel cable are not a theft detection device under the statute. And so...
If the statute's not ambiguous, don't we just apply it as it's written? And if it results in some instances that are overbroad, then the legislature can correct it.
And we would submit that there's that conflict in the language, that it's confusing and vague. I don't know if ambiguous in the sense that it's susceptible to two interpretations is the right way, but in the general sort of common usage of ambiguous, where it's confusing and susceptible to many meanings or not clear, in that sense, we would submit that it's ambiguous because the term is defined in such an unusual way. Getting back to the purpose and the broadness, we would submit that the reasonable purpose of leaving the statute broad would be that these theft detection systems seem to... I've gone over time, Your Honor. May I finish this
Yes,
thought?
you may wrap up. Thank you.
All right, thank you, Your Honor. Is that these systems are things that are likely to change over time. Presumably, they don't want to come back in 5 years and rewrite the legislation if everything's moved from electronic devices to magnetic devices or some other device system that we don't know about yet. Presumably, there's research and development efforts being made in theft detection and designing these systems. And so we would submit that the purpose of leaving it broad is to accommodate changes in the future and not necessarily to encompass all of these different acts that we know about now that would be more thought of as theft prevention. Thank you.
Thank you. The case of State versus Charles Ross is now submitted. Bailiff, you may now adjourn.